Is Doug Fennell going as well?
Doug Fennell.
Who else? Pippi. Jeez. Okay, colleagues, we're going to get started with the voting list. Hope we don't have as many questions as we've had in the last hour and a half. I think you guys have ran yourselves out, so that's a good thing. You said nope. Of course not. All right, so ready to get started? All right, first bill is House Bill 253.
We're not live.
You feel the same way.
That's okay. You're fine, hon. Don't worry about it. It's all right. Okay.
I can talk loud.
Yes, go ahead, sir.
House Bill 253 may actually be familiar because it was voted previously at the last voting session. There is one additional amendment, which on page 8 of the amendments adds 1 year to the date by which pre-existing licensees may expand their canopy. The law currently says they have to finish their expansions by January 1 of 2026. The additional amendment would extend that to be 2027. This is in line with the extension by 1 year also of the delivery of medical cannabis, which was extended by 1 year in the last set of amendments.
For the amendment.
On the amendment, all in favor say aye.
Aye.
Any opposition?
The bill is amended.
On the bill, any discussion?
Version of this out of committee. I just need the number. Was it 1 or 2 down?
Hold on 1 second. I think it's on the computer, maybe. No words. Yeah, we'll come back to that one. We'll come back to that one. Next bill. House Bill 385.
Expands the amount of information that an employer is required to include on an employee's pay stub or pay statement. It also authorizes a private right of action and authorizes either the AG or an employee to bring an action against an employer who fails to comply. There is an amendment in your packet that conforms the House bill to the Senate bill and requires an employer to include dates of work covered by a pay stub or pay statement, requires the commissioner to create a pay stub template and make it available to an employer at no charge, and removes the private right of action. And if there is a violation, authorizes the commissioner to issue an order that describes the violation and directs the employer to provide required information.
Okay. Council, just to confirm, it lowers the penalties as well.
Lowers the
Yes.
penalties. Yes.
Yep.
Yes.
Okay. Yep. Move the amendment.
On the amendments, any questions or discussion? Seeing none. Okay. All right. Amendments have been moved on the bill as amended. Oh, my bad. On favor of the amendment, say aye. Any opposition? Any discussion? Hearing none. Mr. Vice Chair.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski. Delegate Fennell is excused. Delegate Turner. Delegate Valderrama, Delegate Chi, Delegate Frazier Adago, Delegate Adams, Delegate Aaron's, Delegate Pippi is excused. Delegate Jackson is excused. Delegate Johnson, Delegate Rogers, Delegate Amprey, Delegate Weigel, Delegate Fisher, and Delegate Queen. All right, bill passes. Okay, no worries. You ready? Yeah. We're gonna. That's not the citing bill. That's the bill with this technical amendments. Yeah. Okay. Hey, guys, he said don't worry about it on this one because
Okay,
this is the technical, this is the.
this is the technical one.
Yeah, this isn't the controversial one, okay? Yeah, no worries,
I
no worries.
apologize.
All right, so we're gonna go back to House Bill 253. The amendment's been moved. Do you remember?
Yeah, they were.
Okay.
Move the amendment.
Okay, all in favor of the amendment, say aye. Hearing none, any opposed, hearing none.
Move those amendments.
Any discussion on the bill? Hearing none. Mr. Vice Chair.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski. Delegate Fennell is excused. Delegate Turner. Delegate Valderrama. Delegate Chi. Delegate Frazier Lago. Delegate Adams. Delegate Aaron's. Delegate Pippi is excused. Delegate Jackson is excused. Delegate Johnson. Delegate Rogers. Delegate Amprey. Delegate Weigel. Delegate Fisher. Delegate Queen. Bill passes as amended.
Actually, as memory serves, that's about right.
I think so.
Delegate Fisher wasn't there last.
Right. Next bill. 397.
House Bill 397, Public Utilities Thermal Energy Network Systems was considered by the Public Utilities Subcommittee this morning and was given a favorable recommendation with amendments. There are amendments in your packet, or that were sent out rather, that were adopted by the Public Utilities Subcommittee, and there's one additional amendment that Delegate Charkoudian is propounding as well. So the amendments from the subcommittee essentially, this is the one that essentially allows, actually requires a pilot program to be set up by some gas companies to do their underground utilities for essentially ground-based heat pumps. And what the amendments do is to limit the required pilot program to only those gas companies that have at least 75,000 customers, which takes out Columbia Gas and some of the other smaller ones. The additional language, and basically everyone else can electric, gas, and water companies, all of which are underground utilities, are able to produce pilot programs as well, should they choose. Public Service Commission has to adopt regs on decommissioning. If it turns out not to be cost effective, then people are put back onto their old services, and they have. And other than that, there are funds from the federal IRA that are to be sought. The utilities have to pursue tax credits. And then that basically is the large part of it. As I say, those amendments were adopted favorably by the subcommittee. The additional amendment from Delegate Charkoudian would require the establishment and execution of a plan to meet or exceed certain MVE participation goals.
On the first set of amendments, move the amendments.
All in favor? All in favor of the amendment, say aye.
Aye. Now the second. Move the second amendment.
All in favor of the amendment, second amendment, say aye.
Aye.
Any opposed?
Move the bill as amended.
On the bill is amended, any discussion? Seeing none. Mr. Vice Chair,
Aye.
Delegate Harrison, Delegate Boafo, Delegate Howard, Delegate Charkoudian, Delegate Rose is excused, Delegate Pruski, Delegate Fennell is excused, Delegate Turner, Delegate Valderrama, Delegate Chi, Delegate Frazier Hidalgo, Delegate Adams, Delegate Aaron's, Delegate Pippi is excused, Delegate Jackson is excused, Delegate Johnson, Delegate Rogers, Delegate Amprey, Delegate Weibel, Delegate Fisher, Delegate Queen. Bill passes as amended. Next bill, please.
The next bill is House Bill 465, Workplace Fraud and Prevailing Wage Violations, Penalties, and Referrals. It is.
No, go ahead. You're fine.
Okay,
No, you're
go
just
ahead.
talking.
The bill establishes criminal penalties for an employer that knowingly misclassifies an employee, contract, or subcontractor. The current civil penalty is $5,000. The amendment in your packet removes the criminal penalties, preserves the reporting requirement, and increases the civil penalty to $10,000.
The amendment.
On the amendments, any discussion? Yes, was increased. Because we removed got rid of the criminal penalty. On the amendment, you have a question or on the bill?
No, I'd move the amendment and then I'll,
All in favor of the amendment, say aye. Any opposed, say nay. Hearing none. On the bill,
can we hold the
Delegate
bill?
Adams.
Can we hold the bill so I can review it with the interlineated amendments?
Sure. Bill is on hold. Next bill, please.
The next bill is House, 571. It modifies the Family and Medical Leave Insurance Program by altering administrative deadlines, definitions, and components of the program's administration. There are some amendments in your packet that have several changes, including authorizing a portion of the funds, from the Family and Medical Leave Insurance Program to award grants, changes the date that the secretary must submit a report to the General Assembly to November 15th of each year.
All in favor of the amendment, say aye.
Aye.
Any opposed? On the bill is amended. Any discussion? Hearing none. Delegate
Aye.
Crosby, Delegate Harrison, Delegate Boafo, Delegate Howard, Delegate Charkoudian, Delegate Rose is excused, Delegate Pruski, Delegate Fennell is excused, Delegate Turner, Delegate Valderrama, Delegate Chi, Delegate Frazier Hidalgo, Delegate Adams, Delegate Aaron's, Delegate Pippi is excused, Delegate Jackson is excused, Delegate Johnson, Delegate Rogers, Delegate Amprey, Delegate Weibel, Delegate Fisher, Delegate Queen. Bill passes as amended. Next bill, please. This is the bill.
House Bill 805 from Delegate Wilson is cannabis licensee locations restrictions. There are amendments that were distributed. The first amendment is technical. The second amendment basically takes the agricultural areas, addresses a concern actually for a situation in Southern Maryland in particular, requires a cannabis licensee to be actively engaged in growing, processing, or dispensing of cannabis. And then when it comes to ag, require that the property be used exclusively for outdoors cultivation in an area zone only for agricultural use. That way you're not going to be taking an agriculturally zoned area for a grower who is doing things only outdoors, suddenly deciding to put up lots of buildings to do indoor cultivation. Amendment number 3 authorizes, the bill provides for a 1,000-foot limit for the placement of dispensaries. And then the amendment here would authorize a political subdivision to increase the distance limitation for dispensaries to be not more than 2,000 feet. Amendment number 4 takes language from, there's a bill, actually, it's in the House rules, but the Senate has heard the cross file, authorizing license renewal. Residents, et cetera, who are located within 1,000-foot licensed premises to file a protest against the license renewal based on a violation of the law or civil or criminal law, conduct that creates or maintains a disturbance of the peace, obstruction of rights of way, crowds, assault, battery, vandalism, littering, any other violation that the Cannabis Administration establishes by regulation, and then has to says that if a protest is filed at least 30 days before the license expires, the MCA has to hold a hearing unless it finds that the grounds for the protest are no reasonable ground for the protest. And then finally, the MCA has to consider issues arising out of the complaints and the performance for the 4-year period immediately preceding the date of renewal. There we go.
Questions, Reagan Harrison?
Whether the distance between dispensaries was in there. Is there?
Yes, and it was 1,000 feet.
And you increased it to 2,000.
The subdivision to increase it to 2,000.
Yes. Okay. Thank you. I just couldn't remember.
Yeah.
Doug Waffle. Sorry.
Yes, he's there. No,
I mean, we're both really good looking, let's be honest.
Yes, sir.
oh my.
So any protest would still, so local control's gone, any protest would still go before MCA, correct?
Oh, well, the local control isn't gone, but yes, I guess for your definition, I guess, because the state does have some say and we can preclude them from trying to intentionally zone out of the county or the jurisdiction. But there's the protester in there, so if they want, if these places have been placed, if these dispensaries have been placed, and they're causing a nuisance, that license can now be challenged at time for renewal.
Mm-hmm. Only based on the MCA's definition of nuisance and if the protest is considered viable, correct?
Correct.
What's the recourse after the MCA, let's say for some crazy reason, decided that the protest was not viable? What's the recourse? None. So the MCA is the definitive judge, jury, and executioner on that.
The Maryland Cannabis Administration was in charge of cannabis.
Right.
Will be in charge of the licensing of cannabis.
Right. And the protest can go nowhere if the MCA decides that the protest is
on its face invalid. They're just making up stuff. If they're saying we just don't like it because we don't like the smell of marijuana or something like that.
But the localities don't have any recourse outside of MCA protests.
They don't have any recourse now. This gives them. Prior to this, they didn't have that recourse. That was just put in.
Okay, thank you.
The attorney, you have a question?
Yes, just a little teeny one.
Not falling for that again.
Okay, I just want to make sure, this is the bill for location,
Yes.
how many is in Prince George's that you're putting in Prince George's County?
They'll get a total of 21.
21. Okay, no negotiation. This is it.
I don't understand when you say no nego. As in the number,
Yes.
it's done by population density.
Oh, population
So
density.
the more dense counties will get more licenses, obviously. But
Okay.
yes.
Okay,
And they're allowed to, again, before any license is given out, this BP, they have to not only have a building. Thank you. Before any license is given out by the MCA, they have to not only have a location, it has to be zoned by the county. So the goal is to be working with the counties throughout this process for the proper siting. These are multi-million-dollar businesses. Obviously, nobody wants them to fail. And at this point, it sounds like 75% of the applicants are minorities. These are minority businesses spending millions of dollars. They try to go to good areas that they're not gonna, that they're gonna be wanted in. So, yeah,
Got it.
thank you.
Thank-
Doug and Aaron's. Yes.
Is it 500 or 1,000?
It's 1,000, but the jurisdiction can increase it to 2,000.
Okay.
Delegate Fisher,
Libraries, are they included?
yes,
Excellent, thank you.
and churches. Churches, libraries, parks, yes. There's churches,
Place of worship.
place of worship, so.
Yep.
Mr. Vice Chair.
Yeah, thank you. Bob, real quick on the Southern Maryland Amendment. I am very familiar with the topic.
Mhm.
Can you just walk through specifically what is taking
Okay.
place with that?
What I'll read from the reprint, which is that the use of the facility, these are only for the pre-existing facilities.
Yep.
Okay, the ones who already had a stage 1 license and were not actively engaged in growing, processing, or dispensing before October 1, 2022. Providing they were properly zoned and operating on or before January 1 of 23, that says we do let me see where to go. As far as the local, but where the bill says that this is, generally speaking, the locality can't adopt an ordinance that is stricter than what it was for a hemp farm in, as of June 30th of 2023, that says that applies only for those who are cultivating cannabis exclusively outdoors
Okay.
in an area zoned only for agricultural use. In
Okay.
other words, no mixed use areas.
Yep, I got you. Okay. All right. Just wanted to clarify.
And I do believe what it does is it allows them, they can't just start bringing, if they're doing outdoor grow, then that's what they're doing. They don't get to now become indoor grow and start filling up buildings after they've told the municipality or the jurisdiction that they're going to be outdoor grow. I did want to correct, I apologize. All agency decisions are obviously subject to judicial review. So I don't know why I answered you incorrectly. So if there's a protest that was filed and the MCA finds that doesn't have any ground or standing or decides that, they're going to go ahead and relicense, there's still a judicial review process that can be filed an appeal.
Basically, it's APA. That's our Administrative Procedure Act.
Yeah, apologize. Sure.
Give me the date. I mean, this goes in effect, let me get it right. It goes in effect this year, 2000, like July 1 or something like that.
The
For
effective
this
date,
bill?
the effective date of the bill is June 1st.
Oh, June 1st.
Correct.
Thank you.
The amendment.
Okay, so on the amendments, all in favor, say aye.
Aye.
Any opposed? Hearing none on the bill.
Move bills amended.
On the bill as amended, any discussion? Hearing none. Delegate Crosby,
Aye.
Delegate Harrison, Delegate Boafo, Delegate Howard, Delegate Charkoudian, Delegate Rose is excused, Delegate Pruski,
Aye.
Delegate Fennell,
Excused.
apologize, Delegate Fennell is excused, Delegate Turner, Delegate Valderrama, Delegate Chi, Delegate Frazier Aldago, Delegate Adams, Delegate Aaron's. Delegate Pippy is excused, Delegate Jackson is excused, Delegate Johnson, Delegate Rogers, Delegate Amprey, Delegate Weibel, Delegate Fisher, Delegate Queen. Bill passes as amended. Next bill, please.
House Bill 864, Energy Efficiency and Conservation Plans from Delegate Crosby. This is the Empower Maryland bill. The update that was proposed last year and then through Delegate Chi's bill and was redrawn. Yeah. Till Monday.
We're gonna be voting again on Monday. Next bill, please.
All right, next bill is House Bill 915. This is Workers' Compensation Uninsured Employers Fund, timely payment of awards. This bill requires the Uninsured Employers Fund to begin paying workers' compensation benefits within 15 days after the latter of the date an award is made or the payment of an award is due.
Second.
Any discussion on the bill? No, no.
Unfavorable from an uninsured employers fund.
That they don't want to pay in a timely manner.
Well, I'm just looking at the.
No, I got you. Huh? No, I'm saying that all this requires them to do is pay in a timely manner. Not sure what the opposition is. Delegate Pruski.
Yeah, Mr. Chairman, this is a policy decision. As I pointed out in the testimony, if you guys don't remember, September of this past year, they did a report on their finances and they were completely solvent. Again, this is just a matter of measurement, whether like an employer or like an insurer, they pay on time. And simply that's what it is. Again, it's a policy decision, but they disagree. Those folks were appointed by a prior administration, but leave it at that.
At least you know how you're voting now, right? Okay, I believe that's all the questions. The bill's been properly seconded. Delegate Crosby.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski.
Yes.
Delegate Fennell is excused. Delegate Turner. Delegate Valderrama. Delegate Chi.
Yes.
Delegate Frazier Hidalgo. Delegate Adams.
Innovative.
Delegate Aaron's.
What was what?
I'm sorry, Adams was no. He was a couple. He's no, as soon as he said prior administration, we knew where he was going. Yeah, okay. Delegate Pippy is excused. Delegate Jackson is excused. Apologize. Aaron said, he said no as well. Sorry. Delegate Johnson, Delegate Rogers, Delegate Amprey, Delegate Weibel, Delegate Fisher. Delegate Queen.
TJ's not here anymore.
Yeah, right. Delegate Queen. There you go. Delegate Queen was a yes. Okay. All right, next we have House Bill 1296.
Okay, House Bill 1296 is the bill to allow the applicants who have OREX from round one or round two to have a limited reopen proceeding in front of Public Service Commission to basically resize, reprice and reschedule their developments. And they are however, still subject to all of the existing conditions of section 7-704.1 of the Public Utilities Article, save that they don't have to make a duplicate payment to the one of the business funds, which they've already made. There are amendments in your packet. Amendment number 1 is technical. Amendment number 2, based on the letter of information. And by the way, these amendments were adopted by the Public Utilities Subcommittee favorably this morning, along with the bill. Where the bill currently says the applicant has OREX, it also qualifies it that they or are subject to a commission order approving an OREC price schedule as a matter of clarification, because if the turbines aren't spinning, they may technically not have OREX yet. The other thing that the amendments do is to go into the Power Act provisions on DGS procurement and say that essentially they can reopen another round if they don't get bidding in the first time. And that's the amendment that was adopted by the Public Utilities Subcommittee. There's another one that was distributed as well. That is the amendment from the Public Utilities Subcommittee.
Okay. On the amendments, any discussion? All in favor of the amendment, say aye. Any opposed? All right.
There's another amendment that was sent around from Delegate Adams. I can describe it or you can describe it.
So the question about siting, we talked about it in subcommittee about the possibility of within the wind energy areas that are established federally, that we could, while we're revisiting this, perhaps let PSC reconsider siting within the federal wind energy areas. The opposition or concern was that was a federal process we have no jurisdiction on. I did present an amendment to the committee that would allow the commission to consult with the Bureau of Ocean Energy Management. And the quote is on each request submitted under subparagraph I of this paragraph to recite a round one offshore wind project. So I think what my amendment's doing is saying, okay, maybe the legislature will or won't want to get in the weeds on reciting. But if the opportunity arises and BOEM is willing to reconsider the citing, that this amendment would then allow PSC to reconsider citing. And if this is happening outside of legislative session, this amendment may be very helpful to the overall cause, which at the end of the day for Ocean City and for many Marylanders, some of the locations of these wind turbines are just simply too close to the shoreline. And I think most of the opposition and frustration coming from the coastal community is the proximity to shoreline. So I'm going to stop there because this has already been vetted. I spoke about it in committee. The chairman and I had a back and forth on it, did it in subcommittee. So if there's will to move an amendment, great. If not, I'm going to withdraw the amendment and maybe we'll offer it in a different place. No, I can't offer it.
I was listening to the testimony and I do feel for our friends in Ocean City, especially with the fact that the turbines are much higher now than when we first did this. What would be the problem? Is there a cost involved if we had this amendment? I mean, does it hurt anything?
It's basically about starting the process over.
I'm sorry, making, but the delegate made it sound as if it's opened by the federal government, then we could implement this, but we're not asking them to do it. I thought that was the way he was phrasing it.
They're not, because the project's moving forward. There'd be no reason to open it back up because we're not asking them to open it back up. Go ahead.
So what I will say, when I was reading the bill's purpose paragraph, is that we are through this legislation reopening certain proceedings related to offshore wind projects, and it is authorizing these wind projects to submit certain revised plans for project schedule, size, or pricing, including offshore wind renewable energy credits, which I brought up in the committee to the chairman, is that if we're going to revise plans for project schedule, size, or pricing, why not include citing? And that doesn't mean that we will have a revisiting of schedule, size, or pricing, but I'm just saying include it in the purpose paragraph, include some language that says we can't do it without BOEM's, blessing. And if you need it, it's there. If you don't need it, it doesn't have any validity if BOEM's not on board. That's the purpose of the amendment. So I don't think this is destructive to the process. And really, I think I respect the committee's process here. I think you guys have looked at the amendment and I accept the principle that there's some things here that we don't want to reopen. That's a policy decision, right? So I don't want to keep going back and forth over something that the committee's,
I believe we have someone from the PSC that she wants to comment. That's not. Or not. Okay. No, it's okay. If you have a comment, no, you good. All right. Well, again, and this is a policy decision as far as we picked these sites. Well, Delegate Charkoudian, you look at your lights on.
Thank you, Mr. Chair. Yeah, I just want to clarify that the BOEM process takes at least 3 years to get from when they say this could be an area and all the comment to when they're actually bidding the area, then from bidding the area to somebody being ready to start procuring on the area is another 18 months at a minimum. And all of this is if everything goes as planned. And so you're talking now about like 4.5 years. And so I just think it's dangerous if we actually want this to be built. I think it's dangerous for and I know some people here want it to be built and some don't, but if we're assuming that we want it to be built, I think it's dangerous for the General Assembly to have anything that looks like legislative intent that suggests that we would ever consider waiting another 4.5 years for this to be built. We have to use the ones that are currently permitted. And I believe we have to move as quickly as possible on those. And I thank the chair for bringing this bill that'll let us do that.
First off, I think the PSC testified that they felt like they could consider it. Doesn't mean they would consider it, but they could if we give them authorization. Number two, this site, the size of these turbines are much larger than what PSC approved. And that is something that's going to get reconsidered. And this bill allows that the size of these being much taller does have to go through a process. So it's not like there's no process. I think the rub that I was getting was that for some reason citing throws us into a BOEM conversation, but I believe that BOEM is going to have some jurisdiction on the new sizes of these turbines. They're going to have some review of this no matter what.
Well, I'll wait for this. I believe BOEM, you can correct me if I'm wrong, but they already essentially approved the larger turbine to be put in certain sites and they've really deconflicted with something that's important to me with like SecNav or the Navy or any type of range, active DoD range to approve that those things, could potentially go into those sites. And then, obviously I don't think it's wise for us to restart this or reconsider anything to do with siting because I don't know. I mean, it's basically alluded to 4.5 years, but restarting the clock is not just 4.5 years. It brings up a lot of contention. And there's a lot of stakeholder meetings and it costs a lot of money too. Not just for the developers, but for everybody involved to go through that process. It's time consuming. And frankly, it's draining. And so I don't think it is good policy as a body because we've decided that we're going to move forward with these projects to restart the entire thing. We're only trying to look at these 3 things.
Okay, so are there any other amendments, Bob? Okay, so on the bill as amended? Wait, nope. We already moved the amendments, didn't we? Yes, we moved the first set. We didn't move the second set. Those were withdrawn. So now
Move the bills.
on the bill as amended, any discussion? Hearing none. Delegate Crosby.
Aye.
Delegate Harrison. Delegate Boafo. Delegate Howard. Delegate Charkoudian. Delegate Rose is excused. Delegate Pruski.
Aye.
Delegate Fennell is excused. Delegate Turner. Delegate Valderrama. Oh, nope, she's excused. Delegate Chi. Delegate Frazier Dago.
Aye.
Delegate Adams. Delegate Arentz. Delegate Pippy is excused. Delegate Jackson is excused. Delegate Johnson. Delegate Rogers. Delegate Amprey. Delegate Weibel. Delegate Fisher. Delegate Queen. The chair votes yes. We have the withdrawals, calendar. Withdrawal calendar.
Consent calendar. Unfavorable withdrawals, House Bills 1414 and 1365.
On the consent calendar, all in favor, say aye. Any opposed? Hearing none. That concludes our bill hearing today. We have 2 events tonight, one at 6 and one at 7. Take your pick and look forward to seeing everybody tomorrow. Thank you. What? Say that again? So property and casualty will not be enjoying the event tonight. They have to meet.
Yeah, 17 bills.